Hey folks, Jim Wallace here, Executive Director of Gun Owners Action League, and here we are with another episode of, I don't know, what do we call these episodes?
I've been calling it Gun Owners Action Items.
We got to work on that, folks. But anyway, I'm here with
Mike Harris, the Director of Public Policy for Gun Owners Action League.
yeah, there was somebody in the back room taking a marker to their whiteboard going, no, that ain't going to work.
I don't know. It's all right.
Yeah, maybe it's a generational thing. I don't know. I'm just a crusty old dude, so what do I know? Anyway, folks, once again, we want to talk a little bit about what's going on in the legal world. There's some interesting court actions that are sprouting up around the country ever since the Rhode Island case and Snope.
Yep, Snope and Ocean State Tactical.
Ocean State Tactical. I just love that name.
It is a cool one, yeah.
Yeah.
Bay State Tactical.
Maybe that's why, Kennedy and Kerry always had their sailboats there. They wanted it tactical. But there's a lot of jokes there we won't go into on the show.
Right?
Well, that's we'll just move on from that.
Should we say Swift boats?
Yeah. Well, I'm sure they were. Yeah. But anyway, since those cases were pretty much denied by the United States Supreme Court, and, Mike, one of the things you should explain, I don't think we've ever done this. One of the reasons the court denied it was because of the type of case it was.
Well, just where it was in the process.
Right,
More
yes.
like it. So
yeah.
An interlocutory appeal is it's an issue that can pop up where an issue in the case is at odds with the ability to try the case. Yeah. And you can try and appeal it up to a higher court before the case is finished being tried on its merits.
Right. Yeah.
So you appeal to the higher court and you say, hey, we want an answer on this before we can move on with the lower case. Or we think we're going to win and we want to hear what you have to say about it first. So
it sounds stupid, but it's like the old game when I was a little boy, red light, green light.
Yep.
You're trying to skip to the end without going through the process. Yeah. And if I'm right, the United States Supreme Court traditionally does not like
fans.
that. Fans, because they want to be able to read and study what the lower courts.
They want the lower courts to be able to do their job. And if you're constantly appealing higher and higher before the process is over, you're not really going through the process. And the number of writs of cert that the Supreme Court gets in a year is humongous, so they can't hear everything. No. So if something hasn't gone through the lower courts, who are tasked to do that type of work at a higher rate than the Supreme Court can handle, then there's usually no reason for them to take those things up right away.
An old term we used to use is it's not ripe. It's not not ripe for that level of hearing. So those cases are gone.
Yeah.
Mostly because they were not done correctly. Yeah,
they're not both gone now.
No, well, I mean they're not toast, but the Supreme Court's not going to handle them right now. They're basically going to have to go through the process. So anyway, we were waiting. Goal was waiting to see what was going to happen with those cases, and that's why we didn't immediately file an assault weapons or now an assault style firearms case. Yeah. But that is now changing. So there's a very interesting dynamic that's happening, and this one is actually in the Seventh Circuit, right? And you got to love the name of the case, Beavis. For those of us who are old enough to remember, what's that?
This one's Barnett v. Raoul.
Yes, but they refer to Beavis, which I love.
Beavis v. What is it? Case it's
they just call it Beavis. But anyway, so the Department of Justice under President Donald Trump has actually filed a brief in this particular case that Mike's going to kind of educate you on. And you folks know I'm not an attorney, but I've read more law and law documents and court documents than probably I'll ever wanted to admit. But in this case, it's probably the easiest read of an amicus brief I've ever seen.
Yeah.
And they just get right to the point.
It's very cool.
Yeah. So kind of brief us on the brief, Mike.
So it's for the case Barnett v. Raoul. Caleb Barnett is the plaintiff, and Kwame Raoul is the Attorney General for the state of Illinois. And this is a direct challenge to the assault weapons ban portion of PICA or however you want to pronounce it. It's the Protecting Illinois Communities Act. Illinois communities. I hate saying it that way, but I think it's
Well,
I
the
think
easy
that's
way
how
to
it's
do that is
pronounced.
just to fence off Chicago.
Yeah. But protecting Illinois communities. It's not Illinois communities. It's Illinois. It's funny to me. But anyways.
Okay.
but
There's that law school right there. Yeah.
But no, it's so this is a direct challenge to their assault weapons ban. And what we're referring to right now is an amicus brief that was filed by the Department of Justice, and specifically their Second Amendment task force that the president set up recently. It's headed up by Harmeet Dillon and Chad Mazel. It is pretty much a straightforward roadmap of how to use the large precedents in these cases in Second Amendment jurisprudence, or especially on the federal level, to kind of get to the Bruin test, I guess.
Well, it's almost like a Bruin handbook.
Exactly. It's a McDonald, Heller, and Bruin handbook. And it even refers to Rahimi in a positive light with some of that stuff too. So, but no, if you can find it, I'll put a link to the actual amicus brief in the description down below. But it's great. It's only two sections. Well, it's only two parts. Each have their own section. Have three sections, A, B, and C, and it kind of just walks through how to use McDonald, Heller, and Bruin to challenge assault weapons bans across the country, really. And it keeps referring to the AR-15 as the paradigmatic example of firearms that are banned because it's the most popular rifle in the United States, and it's the one that is the most targeted by these types of laws. And what they mean by paradigmatic is it's basically like the Honda Civic of, rifles in the United States at the moment. It's the.
So my question is, why don't they just say that?
Yeah, exactly.
Well, what's interesting is before the show, Mike and I were just kind of rehashing some of the old cases, and we're going back now with this to Miller, which was 1930s.
Yeah,
maybe?
30s, I think.
Yeah, and Miller was an interesting case. This guy was a moonshiner, and the feds were trying to nail him for years. And the only way they found a way to nail him was, well, they found his truck, and they found a sawed-off shotgun in his truck, and that's how they went after him. Now, this thing went all the way, pretty sure it was to SCOTUS,
Yeah,
right?
I think it was the first challenge to the NFA, right?
Yeah. Well, no, this was way back then, wasn't it? Yeah, it could have been. Yes,
NFA was the 30s,
yeah. Actually,
because the NFA was put in place
that's right.
to battle concealable firearms from that moonshiners and bootleggers were using during Prohibition.
So it's interesting that the defendant Miller never even showed up to court because he didn't care. But the court ruled, interestingly enough, back then that a sawed-off shotgun had nothing to do with being a military gun.
Right.
And therefore was not protected by the Second Amendment. Now, let me repeat that. They said because it was not a military-style gun, it was not protected by the Second Amendment. And the antis hung their hat on that case until the,
Forever.
80s, 90s. And
Forever.
then they said, we change our mind. We don't want these things.
Because firearm technology finally caught up.
Yeah.
It changed enough where they were like, oh, no, we can't use this anymore.
So interestingly enough, in this brief filed by the DOJ, and Mike pointed this out, they're trying to really make a line of demarcation between arms that are protected by the Second Amendment versus things like artillery and so forth.
Yeah, which is kind of depending on which side of the argument you really want to use and how many people you want to scare away is a little bit frustrating to me, because when you look at the history of the Second Amendment, especially during times of war in this country, you're looking at privateers and corsairs and folks down in Texas with their "come and take it" signs about their cannons. And, we talked about crew serve weapons and bearable rifles and things like that, where in this they are constantly referring to weapons that can be worn, borne, or carried for offensive or defensive action in case of conflict with other people.
That's an interesting point too, because I've never seen that before. That this is the first time I've actually seen a government document or official use the word offensive, not just defensive.
Well, that's kind of where for me, where it's kind of doesn't make sense, where they're arguing that crew serve weapons aren't okay. Because if we're talking about offensive uses of firearms, we're talking about the prevention of a tyrannical government. I'm assuming that's where we're going with this. And, you know, I know we have a couple of examples of folks in third world countries who have done some damage with bearable arms when they're up against the U.S. military. But, you know. That's
true. As a matter of fact, I'll tell you a funny story about what you just referred to, because I was at, it was, I think, during the 2014 stuff, and there was a so-called roundtable at a school. And, you know, they had Representative Dave Linsky was there, and a guy from Stop Handgun Violence was there. And the guy from Stop Handgun Violence, you know, we got the whole auditorium is full of people. And he said, Jim, do you really think you guys and your little rifles are going to take on the U.S. Air Force if things go bad? And I said, well, first of all, the men and women driving those planes are our friends. They hate you.
Yeah, they're not your
So
buddies.
if it goes down and you're driving down the highway, if you see a little red squiggly light on the hood of your car, I'd get out, because they're going to take care of things. But it's insane that they want to bring it to that point where they're going to say the military is going to come after us. You know, I was in the military. They're not coming after us, trust me.
Our previous president, you know, hey, man, you have 15s, man.
Same guy who just said fire a couple of rounds in the air. You know,
oh, my God. Tell everybody in the country to commit a felony. Just get a shotgun, fire 2 blasts.
Yeah. And I always pictured Secret Service guys dropping dead out of the tree after he did that, right? So, yeah, it's like, Joe, don't do that again.
Poor Jill's trying to bring the groceries in.
Oh, my Lord. So it's the dynamic. Yeah, the dynamic is changing quite a bit.
Yeah.
And it's a refreshing position to start to work from again.
Yeah.
Even though it's the same challenges, we're going about it in a little bit of a different manner.
Right.
The onus, and we've said this forever.
With some of the federal government on our side.
Yes, for a change. The onus has always supposed to be on the government.
Yes.
To prove beyond a shadow of a doubt that we should not possess something. This isn't uranium. Matter of fact, when we talked about, you know, artillery, again, I was another roundtable. This one was at a church, and there was a senator, a police chief, and a few other people. And a guy in the audience finally said, "Well, okay, I'm going to get to it because it's got to get there eventually. You know, why should we be able to own an AR-15? Because you can't own a tank." And the police chief sitting next to me, I said, "Chief, do you want to tell him or should I?" And he's like, "No." And I said, "Yeah, you can actually own a tank.
Sure can.
You know, you have to do something special with the main gun, but you can own the tank."
In some circumstances, you do.
Yeah.
There is a place down in Texas that is privately run called Drive Tanks, where you can go and fire artillery shells out of an active tank. And they are privately owned.
Yeah,
and that's the other side of this thing. I'm going to steal an argument from Tim Pool, who I enjoy watching his show. But he made a really good point about the private ownership of nuclear weapons. Who do you think manufactures nuclear weapons, Jim?
Well, it ain't me.
It's not the federal government.
I know that.
So at least for a point in time, before they are sold to the federal government, they are in the hands of private individuals. Yeah. Might be a publicly funded company. Yeah. Or publicly held company, but they are still in the hands of private individuals. So
somebody go tell, was it AOC and Crawford down in Texas that and see how they react.
It's one of those things.
Oh, yeah. Yeah. Well, it's just like any other, crew-served weapon, a tank or anything else. It's in private companies that are making it, and missile launchers, whatever. I had a
all
friend
privately owned until they're not.
Right. I had a friend I talked to you about that used to be in the machine trade, and his specialty was shock and vibration.
Yeah.
He was the guy who built the stress test machine for the original Patriot missile system.
That's cool.
So, yeah, it is pretty cool. And he did a lot more work. So there's always private sector people that initiate military or civilian arms. I mean, that's the way it works, right?
I mean, John Moses Browning's name was not the government. So it's all. Where do you think these innovations come from and all this stuff?
Well, what I think is interesting, if I remember my history, and correct me, people, if I'm wrong, which I know you will, that Browning did some of this stuff because his son was in the war, and he wanted him to have reliable guns. Yeah. He's like, okay, that stuff you got is crap.
Yeah,
here's a good one.
That's the story with the Gatling gun too.
Yeah.
It's all that stuff.
Yeah, well,
That's where it comes from.
I met a gentleman at an NRA event who was in Bastogne during the Battle of the Bulge.
All right,
and he had his 1911 that his father had sent to him.
That's
because
cool.
He said, I want you to have a reliable backup. And the story from him was, we had run out of rounds for the rifles. We had an excess of 45 because nobody carried them. And in the end, that was the only defense my squad had, was my 45.
God, that's terrifying.
So, yeah, imagine that. So anyway,
at least it's a light trigger. You can pull it with frostbite, right?
If you had a finger left,
I'm just saying, 1911's best frostbite gun out there.
Yeah. Well, do you know, going off topic, but do you know the original M15s and the AR-15s? The bottom of the trigger guard drops out so you can use
it's a winter trigger.
Yeah, winter trigger.
Which is a funny thing to add to a gun that was designed for jungle warfare.
Yeah, well, exactly. Yeah. But those of us who went through training with those guns, the first mud puddle you went through, they were done.
Yeah, that's the old ones. The new ones aren't so bad.
They were
anymore.
Toast. So anyway, what this is all leading up to is basically we have 2 more court actions that we're working on with our federal court specialist, Jay Porter. And as some of you have met Jay already, Jay was on the ground floor of the Bruin case in New York. He did not go to the Supreme Court. It's not what he does. But he was on the ground floor to design the case of Bruin. And now he's working for us. Now, the first 2 cases we had, right?
Yep.
Training. And long gun.
Long guns.
And those 2 cases, the training case was actually designed and filed, which costs a lot of money, and then was basically made moot because the legislature,
by the agility of the legislature,
they can move fast when they want to, aren't they? Changed a typo, they said.
Yeah, typo.
And suspended training requirements, until state police or whoever gets off their duff and figures this stuff out.
That's a whole nother story.
The other piece was the long gun testing and roster that would have been exactly like the handgun stuff that we had developed the case, was ready to file as soon as we announced it file. They announced that they were not going to do that anymore. However, they've never put that in writing.
Nope.
So
no, but the Secretary of EOPS hasn't put anything in writing for a while.
November.
Yeah. That was it November or December was our last guidance letter?
Pretty sure it was
November.
Well, it doesn't matter.
Yeah.
It's 7 months ago.
It was enough time ago.
Yeah. Which I don't think we're ever going to see any more guidance because every time they write guidance, they weaken their law. So the next 2 cases that we're pretty excited about, and you'll see stuff go up online either today or tomorrow. Jay Porter is working on one going after the assault-style firearm, and he was very excited about the DOJ getting involved in this stuff and what they were writing.
I mean, this is a roadmap. The feds wrote this.
Right.
That is unheard of.
And the other one, which is a little more complex, is basically going in federal court after the entire Massachusetts licensing regime. Yeah. Because it is not only just unconstitutional, it is prohibitive Mike, you said about the non-resident, if it takes a year to get a year's license.
Yeah, I that's my theory on this whole thing. If you are applying for a license that is going to last you the year, and the purpose of your application is to get it for that year, and you are delayed a full 365 days before your license is issued, I think that's a denial.
Yeah.
I think that's a denial of your license because you have to apply every year. So it's a year-to-year license. So it's not like you have one and it lasts for 6 years like the in-state does. You don't have a license unless you have one for that year. So I don't know. I
even if it's not
a substantive
denial, it's a suspension of rights, know, because you don't have it.
I'm just saying, if you apply for a license that lasts a year long, and you are not issued that license for whatever reason, whether it be a broken printer or whatever other silly reason they have, if you are denied that license for a full 365 days, that is a denial of your license. I get the arguments that, you'll eventually get it for the next year, but that's for the next year. That's not for the year I applied for it for.
Right.
But, that's for smarter legal minds than mine.
Under the law, as we understand it, if you're a non-resident, don't bring any gun for any purpose into the state without a non-resident. Well, technically it's called a temporary license. John always corrects me on that. But don't bring anything, even if you're hunting. I don't care what you're doing. The exemptions, as we have read them, do not cover that. Now, we've had some people, and those people sometimes are on FCAB, that actually don't know how to read law, keep pointing to things that don't exist. So all we're saying is don't be the test case. Because
unless you want to be.
Well, But I mean, how many non-residents have been hung up and just since the thing has passed?
I mean, I can think of like 4 examples off the top of my head right now.
Yeah. Yeah. I mean, the local attorneys that we work with are constantly taking cases from non-residents that are getting hung up on this
We
stuff.
have one right now about a guy in Maine that we're looking at helping out on.
Yeah.
So
Yep.
depends on what the facts of it are and what the gentleman is like, but yeah.
So anyway, we got 2 big cases coming up. And now is the time where I'm going to tell you, ever since this stuff started and it got passed and we knew we were going to have to go to court, I have continually said, I'm not going to ask for money unless we need it. Guess what? We need it now.
Yeah.
These cases, if just these 2 cases, if they have to go to the Supreme Court, which we know we're not going to win in the 1st district here. It's almost like the new mayor of New York going to the 1st district court. So I think I just set Mike off. So likely, unless something happens that fixes everything nationwide, we're going to have to go to SCOTUS. And these 2 cases combined, going to be somewhere around $1 million. This is not chump change. And I warned all of those naysayers when we were fighting this stuff, just stop this and go to court. Okay, now it's time to get out your golf checks.
Yeah, we're going.
And help us out because we're going.
We are directly challenging the assault weapons ban.
Yeah, but we can't go without the funding. So it's crucial now that we be able to raise a substantial amount of money. Now, we're going to get a little help from our national partners, but this one is on us. They're going to step up to some extent, but they are also busy nationwide. Well, I shouldn't even say nationwide because it's only about 5 or 6 states now that we have to beat on.
The dirty dozen.
Yeah. So, but now it's crucial, folks. Now it's time to basically, pony up.
We got to beat Rhode Island to the punch.
Yeah. They're kind of slow in Rhode Island anyway.
Yeah, so are we.
Yeah, that's true. But anyway, folks, we're kind of excited now. To some extent, the the reins are off because we don't have to wait for the other 2 cases anymore, and we can charge forward on our own. And it was part of a national strategy to not file something in the First Circuit while those 2 cases may have been considered. But now it's, okay, gloves are off. Let's rock and roll. So I'd like to thank everybody for their support up to this point. And I hope we can count on even more people's support as we move forward with this action. It's not going to happen tomorrow. These cases sometimes take years to get through the system. The last time we did this, it took 2 years.
But we are currently drafting complaints for both of these.
Yep.
They're in draft mode. We have attorneys that actually have assignments from us and from the NRA and SAF at the moment.
Yeah. Well, there's, like I said, the national partners. Whoever comes in, we'll let you know who's going to join into what. There are other cases already going on with our national partners. The non-member stuff, if it's ever filed, is being handled jointly with the Second Amendment Foundation. The 18 to 20-year-old case has already been filed, and that's got darn near everybody on the national level, including us. It was like a keg party went to that thing, and it just had fun. So everybody's going to be on that. So, folks, thanks again.
Yeah, thank you.
We'll have news out when these things are filed and ready to rock and roll. And stay tuned. This is going to be a ride.
Yep. And we'll continue to update you here as we move things along as well. So,
thanks, folks.
Thanks.